Look, sir, should we get started?
Yeah, we can start. Good afternoon to everyone. I, on behalf of the ICI and on behalf of the Invest India, welcome you all to this platform for the growth of the economy of the country. The subject today is the joint ventures in India and interactive sessions for the foreign investors on building partnership in the country. We have with us Prerna Soni, the senior AVP from the Invest India. She'll be taking the position as a moderator. And we have the speakers around us. Suraj Malik ji, who happens to be a chartered accountant from the as a professional and the partner with the BDO India. Lalit Kumar ji, a partner from the JSA Advocates and the Solicitors. Gaurav Sehgal ji, country head from the international subsidiary banking from the HSBC. We do have our co-chairman from the Committee for the Export of CA Services and WTO of the Institute of Chartered Accountants of India, CA Dheeraj Khandelwal ji with us. We, as a team, with an objective to bring out the best to each one of you, to understand the strength of the country, India, to bring out best in the economy of the country. And you see, like India has traveled a journey since 1992, have taken a different transformation and the reformation steps so that we have reached to this level. And maybe journey is a continuous journey, which may in the time to come will be better placed also. Friends, as we all are well aware of the ease of doing status of the country, we have really reached to a level, and definitely in the time to come a level step ahead will be there. Regulatory reformation has already been under on the way, and it has so many reformation has already taken place. Foreign trade has also been eased out, whether it is doing exports and imports or bringing out any manufacturing activities or services activity in India is naturally a strength for the country. This is because of the so many reformation, the strength of the skill professionals here, or the strength of the each and every whatsoever the needs is been required at the manufacturing setup. Those are the advantage, and India is considered to be a land of opportunities, huge potentials for the internal trade also, for the external trade also. And those are basically the steps which make us more stronger, and maybe in the time to come more and more stronger. And on behalf of the ICI, ICI has its own strength of 3 lakh chartered accountants, more than 3 lakh chartered accountants, strength of the students, all knowledgeable to serve the profession and serve to the India as a good background of the economic structure of the country, those kind of strength. And joining hands with the Invest India and ICI has entered into an MOU to take the India forward in the economic front, like a barrier at the not only border but economic growth for the country. Naturally, financial professional are the professional who understands the business, who understands the economy, who understands the way forward. Also, if they join hands and both of them taken a lead to join hands, and that bringing out joining 1 plus 1 is equal to 11, it is always been a which we always thought of since our childhood time, कि once a good sportive hands is there with you, so it is not you are helping them, it is helping each other. So those kind of strength is with this ICI also, with the Invest India also. And we are fortunate enough that different programs at a different point of time has been taken a lead, whether it is the IFRS program, which we had very recently. Now it's a joint venture or the merger acquisition, or the way we can bring out the money into India for the growth of not only for the India, for the growth of the joint venture partner also. And the whosoever partners with, definitely it goes hand holding and it goes for the growth of each and everyone. With these kind of objectives, these programs are been happening with, and it will continue to be giving the support to the economy and the industry as such. With these words, I once again welcome all the participants, all the speakers, and the participants, and my co-chairman also, and the Prerna from the Invest India also. I, on behalf of the ICI and on behalf of the Invest India, welcome you all. Over to Prerna.
Thank you so much, sir, for your warm words. Welcome everybody to this session, this webinar that we are conducting today on joint ventures in India and how to create successful partnerships in the country. I'll start off with first introducing myself and my organization for the benefit of all chartered accountants and the investors who we have with us today. Invest India is the national investment promotion and facilitation agency of the Government of India. It's been set up under the aegis of Ministry of Commerce and Industry, and we focus on sector-specific investor targeting and facilitation. Our main aim is to increase more and more investments in India. We were set up as a not-for-profit agency in 2009, and since 2015, we have been proactively working to work with domestic and international investors to help them invest more in the country and help India reach its 5 trillion economy dream. About myself, I'm a chartered accountant by profession, and I've been working with Invest India for over 4 years now. My focus has been to work with financial investors from all over the world, including sovereigns, pensions, private equity, and VC funds. And I work with the government of India mainly to attract investments in the infrastructure space. Today, when we started talking about investments coming into India and the influx of money that the country is seeing, we thought one area in particular that is of significant interest to investors outside and to domestic players in India is joint ventures. So we thought along with ICAI, we will do this webinar wherein we get you experts from chartered accountants, lawyers, bankers who would give you a very candid view on what really is happening on ground and what is it that as a community of chartered accountants, lawyers, bankers, we can do for investors. And as investors, the idea today is to answer all your questions and to give you as much candid information as we can on this particular topic. With that, I'd like to now introduce my panel to you. I'll start off with Gaurav Sehgal, who is a postgraduate in international business and he has a combined work experience in wholesale banking for over 19 years. He has worked in various large private sector banks and he joined HSBC in 2004. Since then, he has worked across markets within India in global banking, global trade, receivable finance as the India sales head, regional director, South India, corporate banking. For the last 4 years, Gaurav has been focused on international subsidiary banking as the country head of HSBC, wherein for HSBC corporate banking MNC franchisee, and he also heads the Western India Corporate Bank as the managing director. The international subsidiary business is a key focus area for HSBC across the group and in India, and it involves managing and growing the corporate bank's MNC franchisee and networking across. And along as a part of his Western India role, he has been managing large Indian companies as well. Welcome, Gaurav. Thank you for your time today. I'd like to now introduce Suraj Malik to you. Suraj is a partner at Video India LLP, who has a focus on M&A, JV, startups, and deals. He operates out of their Gurgaon office and has over 18 years of diverse experience with large accounting firms, banks, and family offices in India. His area of expertise includes deal structuring, fund structuring, inbound investments, M&A transaction, corporate restructurings, JVs, succession planning, family office, and private equity. He has led and managed several transactions across multiple sectors such as media, hospitality, real estate, IT, SEZ, and other general manufacturing industries, and several marquee transactions in the startup ecosystem as well. He has also advised and implemented one of the largest family settlements in India and structured and executed succession strategies for HNIs and entrepreneurs. Suraj has spoken on various national and international events organized by different institutions, and we hope we can get very insightful information from him today as well. Welcome, Suraj. Thank you for your time today. And I'd like to now introduce Lalit Kumar. who's also agreed to join us as a panelist. Lalit is an M&A and PE lawyer, and he advises companies and institutions in corporate commercial transactions, including private and public M&A, private equity, JVs, corporate restructuring, FDI, offshore investments, and advisories on corporate law. He has worked on various notable deals over the past, including exit by India Bulls from all of its commercial assets in a sale to Blackstone. He has worked on the UPL's largest acquisition of $4.2 billion of Arastia Life Sciences. And he has also worked with Microsoft Corporation's acquisitions of minority stake in Robotic Wares Private Limited. He frequently writes various columns on legal issues in financial newspapers and is, of course, a frequent speaker in a lot of these events. Welcome, Lalit. Thank you so much for joining us as well. With that, I'd like to directly jump into the topic that we're talking about today, which is India. We're talking about joint ventures in the country, but everybody goes back to why India? Why is there an influx of this discussion, and what really has happened? And what actually has happened is India is a transformed nation. We are a new nation with social, political, economic pillars and aspects all growing towards making India a fast growing country, and India is currently at the bottom end of the hockey stick, moving towards achieving its 5 trillion economy target. And today, in the midst of this pandemic, India has a new vigor, it has a new drive, which is the Atmanirbhar Bharat campaign. What really is happening in India right now is that we are moving towards a self sufficient country. As we all know, only last week India imposed a restriction on import of colored televisions, which means all international players who were crowding out our market by low cost products will now have to actually come into the country to manufacture, which is crucial considering India alone has a target of reaching a 5 trillion consumer market by 2025. Looking at that and also looking at the global trade wars and where India falls in as at a very, very attractive position amongst all global investors for their diversification strategy. Today, the idea was when foreign investors are looking at India, one option which is available with all of them is coming to the country as a joint venture. Today is the chance for Indian companies to partner with a lot of foreign players for technology, partner with strategic investors from outside and institutional investors. And hence, today, along with giving you a pragmatic view of what goes on into setting up a GV from a legal aspect, from taxation, from banking, hopefully by the end of the session today, we would leave you with certain successful snippets as well as to how is it that you can come in to India in a successful JV. With that, I'd like to first move on to asking Suraj about what are the benefits of actually coming into India as a JV. We all know India is a huge market for foreign investors. Only last year, we saw 74 billion of FDI coming into the country. And we have made a lot of announcements, such as the National Infrastructure Pipeline, where we very clearly say that India would be looking at significant number of international partnership happening. And the government is focusing on attracting a lot of foreign capital. The FDI guidelines in India are also significantly liberalized now. In fact, if we go out and do a mapping of India as against a lot of other major free economies, India is one of the most free economies with respect to FDI regulations. In this aspect, why should a foreign company who's looking to come to India come in by way of a joint venture? Why not come in on their own? How is it that a joint venture helps them, Suraj?
Thanks so much, Prinna. And, we could talk about attractiveness of India perhaps all day, and, it continues to be something that entices foreign investors. Given that the period we are, traditionally as well, we have a lot of evidence that after every economic downturn, in every recovery period, the M&A activity kickstarts with a joint venture. And the reason being, it sort of allows a foreign player who wants to enter India to sort of de-risk, lower capital intensity, find someone to sort of complement whatever they want to do, versus entering a new period or a new phase outside of what is there or outside of what they would expect, because things will take time. Yeah, can you hear me? Basically, what I have seen is, there are sort of these five-prong approaches that investors use to enter our country. If manufacturing is non-key, you could start with an e-commerce or a pure distributorship, right? We're just sending goods to India, etc. And now with the importance of getting things made in India and for being able to do retail in India, that model may not always work or in all contexts work. The next sort of tier is where people do contractual ventures. They will do an alliance or some sort of a licensing for technology to an Indian partner without creating a formal legal presence. Again, these are maybe, it's just a staggered way where the person is thinking, let me start with this, eventually I will do. You could have branch office. We have concepts of liaison or project offices, again, for very, special purposes. But the question, what you asked was actually a choice between having an own entity, 100% entity that you own, you control, versus a joint venture. Joint ventures clearly less risky. This is a different market. If someone is entering, they could, as I said earlier, also partner with someone. Uh, Very importantly, this in India or a country like us, where the existing businesses are not always willing to sell, and in this environment where valuation is an issue, you could also get access to assets which were not otherwise available. I mean, people are more open to do joint ventures, more open to sort of dilute holding and jointly build value, and then sort of over a period of time permit the foreign investor to get full control. Uh, Also, this is the fastest mode of accessing Indian market if your JV partner has access to customers, has a distribution network. Creating all of that in your own setup is a very long and high capital intensive project. Similarly, like any other country, if you enter, to have proficiency in local language, customs, hire the right sort of employees. I mean, doing it on your own in a new geography or territory is always difficult, not just in India where people go. But in India, yeah, we have our own specific cultural issues, and to be able to then compete with other local players, a joint venture will, or we have enough empirical evidence to suggest that joint ventures are able to do that better. So it's essentially like we have seen so much in the startup world. It's like having a co-founder who will share responsibilities, who will partner, the foreign strategic investor coming into the country, and the probability of the success is way, way higher, I would say, compared to coming alone at, especially if it's a new project or new area. Back to you, Prem.
Thank you so much, Gaurav. So, of course, joint ventures do help in breaking through the complexity of a vast and difficult market that India is. Gaurav, can you give us your two bits on what do you think, considering the ground reality that you see as a joint venture, as an expert and the MNCs that you work with? Why do foreign investors look at JVs in India?
Thank you, Prerna. And I think Suraj clearly rounded up quite well when he spoke just now around what are the drivers of getting into India through the joint venture route. I think if you look at a banking perspective to it, or if you look at my humble perspective, which is kind of gained more from talking to various companies on the ground, I think there are two or three very important aspects that the way I look at the country, and more importantly, the way I've seen some of our investors, look at the country. I think first thing is that India is really exciting, right? Because you cannot, it's very difficult to look at India as one market. I think that's the most fundamental difference between India and various other geographies in the world. Is that if somebody comes into this country looking at having a one size fit all strategy, which says that I will, sell something, or I will sell something for, or I will sell something how, which is which is uniform across the country, then we've clearly seen a lot of mistakes being committed. So I think one is about really looking at the investment into India as in different pockets, or more importantly, in different parts of the country, and really trying and aligning a strategy which kind of takes, which is scalable, of course, but which is aligned to a particular part. So I think the first fundamental thing is to look at the market, right? The second important aspect, as Suraj also mentioned, is that what is the force driving it? In the sense, what is it that you are seeking when you come into the country? Are you looking at a distribution? Are you looking at manufacturing facilities if you want to look for a contract manufacturer? Or are you actually looking at something as somebody is going to get you all the various approvals that are needed on the ground to get things started. So I think there are different forces which kind of drive this particular decision. But clearly to the question, it's we do see a lot of joint ventures become a lot of investors come into India and say that this is a land of bolt-on. At the end of the day, you've got a lot of opportunities that are available with family-run businesses, with businesses which are private limited, which are scaling up. And some of the investors from Europe, from the US, really look at it more as a bolt-on market. Now, as we know, when you look at a bolt-on market, there are valuations which will not always be in sync with what your expectation is. And hence, in order to get a piece of those valuations at the right price, or to get a sense of those valuations, I've seen a number of multinational companies look at the route of a joint venture to kind of come in and kind of take benefit from what they're learning on the ground. So I think what we have seen very clearly amongst the other drivers that Suraj alluded to is also a game of learning as to how do we come in and learn the complexities of India, which is, in some shape or form, very different to the other markets of the world. And then how is it that you kind of build up on that learning? So that's something that I have seen, on the ground as a banker at least in these many years.
Thank you so much. And I absolutely agree. I think we've seen cases of US auto companies which could not succeed in the market because they didn't really understand what India needs. And we've seen how the market, you go 100 kilometers in the market, perceptions and choices completely change. So absolutely, those learnings about the Indian market and ecosystem, of course, coming in with the partner. Just a quick message for all of our audience, in case you guys have any questions for our panelists, please feel free to put it in the Q&A section, and at the end of the session, later we'll be picking up questions as well. With that, I'd like to move on to the legal aspect of it. Looking at India and what we've been doing over the last 5 years, we've changed our story. So there's a huge impetus that India has put on ease of doing business. We were able to move from 142 to 63 in the ease of doing business ranking in less than 5 years. At Invest India, when we work with a lot of these foreign investors who would be registered in other countries, they might register themselves in some Southeast Asian company, but they're doing business in India. In a lot of developed nations like this as well, we've seen setting up of a power of attorney might also take 10 days. But India that way has changed a lot of things. So, looking at the Indian perspective, foreign investors are, for example, now permitted both in company and LLP aspect to come in and set up shop. And this gives investors a choice to select an appropriate structure which is very suitable to their business objectives and their financial and capital structures. Lalit, if I could bring you in here to talk about the regulatory considerations that an investor has to keep in mind in line with the recent changes, and what is it that the investors should really take note of here?
Sure. Thanks, Prerna. I think just carrying on the conversation which Suraj and Gaurav said, I think one reason, before I get into your question, even one reason is a legal reason to have a JV partner. For example, the sectoral caps that we have, some of the sectors do not allow 100%. They are regulated sectors, including for insurance. So there is also a compulsion that you would need an Indian partner. So now coming to your question, I agree that a lot of ease of business and liberalization has happened. And you are right in the rankings that we have improved upon. It's not only which is on paper, in reality. Why I say this is I have been in practice of law for 18 years. And I know the days when everything required government of India's approval, when foreign investments had to come. Things have been liberalizing, both in terms of the sectors where things which used to be under the government route are now under the automatic route, which means you just don't need anyone's approval. Get the investment and just file the paper of investments with Reserve Bank, and that's the end of the story. You also rightly mentioned, Prerna, about the ease which is also given on the kind of entity one can set up. Both LLPs and companies are allowed to set up. Fortunately, they have almost a similar process to set the entity. Even from an FDI perspective, LLP has been allowed as as a route or as a mode of entity into which investment can come. The only thing is that the sector shouldn't be one which has any FDI linked conditions. So over a period of time, what I have observed that whether it is setting up of the company, JV company, or it is even setting up of an LLP, both are recognized modes and both have also got little easy in terms of setting up. I'll give you one example to just emphasize the point that I said. If you now want to incorporate a company, and it doesn't make any difference really whether you have a foreign investor or an Indian investor or a mix of two, except for little paperwork increases when you have a foreign investor. So there is a single form now, which means when you go and set up a company, you can click all the options which will get you your even the GST number or your employee state insurance, EPF, professional taxes wherever they are applicable, for example, in the state of Maharashtra. So much so that you can even click on the option of the bank account that you want to open the bank account with the company eventually when the company gets set up. So the investor can just click that single form and get the entity registered. Unlike earlier times where it used to take unusually long, ideally now, if all the documents are great and in order, which is where professionals can also help, it would not take more than 5 to 7 days to get a company up and running as far as the registration is concerned. So definitely, I see a lot of ease of doing business, and the reality is, and the reflection is already there in the rankings that you just mentioned, Prerna.
Thank you so much, Lalit. Suraj, can I request you to give a taxation perspective here more so when somebody is looking to set up a new JV in the country?
Absolutely. I think tax is one of the tangible things that investors look at because it is a cost. While, Lalit clearly agreed, we are very efficient, in fact, on par with developed countries when it comes to incorporation, setting up the whole ease of it. I sometimes jokingly say that Google has to catch up with the liberalization in our country because some of the articles where people look up don't find the reality of, what the process is today. But tax-wise, I think between companies and LLP, the budget before last, we had a big liberalization on tax rate for new companies. And, here because we are talking JVs and this could potentially be new companies or existing. For new manufacturing companies, now we have a tax rate of 15%, which is very, very competitive if you look at the entire Southeast Asian region. And to attract manufacturing, including on JVs, that benefit is available only to companies. Currently, it is not available to LLPs. And even for non-manufacturing, the tax rate for companies was reduced from 30 to 22 since October 2019. This announcement came in last year. This benefit also has not currently been extended to LLPs. So if the business model is really a lot of, getting money, creating manufacturing or other assets, so the money will largely be redeployed, a company is a good answer to have. The advantage that LLP has, and it might work for sectors which generate surplus cash faster, including sectors in services, etc. We don't have a second layer of tax. So after paying the tax, which is 30 for LLPs, distribution of that to the shareholders doesn't involve any taxation in India. For companies also, we have a big change in the regime. Earlier, in the Indian company had to pay a tax, which we call the dividend distribution tax. That got abolished, and it really works very, very well for foreign investors across countries. And now, really, we have a withholding on dividends, which the investors would get a credit in their countries, whether they come from UK, US, etc. So, in spite of the second layer of tax today, companies would generally be a good answer for manufacturing or new manufacturing. And in other cases, you just need to model and see which gives you a better answer. I had just one more point. Non-tax, which is important, is also on financing. If we are also allowed, our ECB or our debt norms had got fairly liberalized. It's very easy to now bring debt into India. And currently, ECBs are only permitted in companies. So if the financing structure involves a foreign investor putting debt to fund the venture, I think then also necessarily you'll end up choosing a company.
Perfect. I think that is absolutely helpful. Lalit, I want to understand. So, when somebody is actually looking at setting up a joint venture, to give investors an overview, what are the kind of JVs that one could set up in the country, and what are the kind of compliances they would need to keep in mind for this?
Sure, Prerna. See, in order to set up a joint venture in India, the most preferred entities or modes are company and LLP. There is a concept of an where you actually just do not have any entity, but just write a contract and become a JV partner, which we typically say are unincorporated joint ventures. Even in income tax, there is a provision with respect to that. That is very rare, and I haven't seen that kind of unincorporated joint ventures being entered into. Precisely, it requires even Reserve Bank of India's approval, because you are setting up a business without having an entity into something which is called having a place of business in India, which requires Reserve Bank of India's approval. So let's talk entities. So the preferred mode is company and LLP. As I said earlier, in terms of the setting up, it's relatively easy now, and the paperwork is also. Although LLP over a period of time is gaining importance, acceptance, but today even the reality is that most of the time the joint venture partners prefer to have a company, and that too generally because if it is a beginning or a startup company, so it is a private limited company. So broadly, if we focus on, and there's no legal restriction, we can have a public limited company also, but generally we see because of having fewer number of shareholders and having lesser regulations which should apply to the JV entity, so the JV partners do prefer a private limited company. So broadly, the compliance for a private limited company, once it is up and running, is of course you need a bank account, an audit firm as a compulsory auditor. There's a minimum requirement of having 2 directors in a private limited company or 3 in case of a public limited company. Then one of the important conditions which has come in the new Companies Act from 2030 is to have someone who's called a resident director. So if a foreign joint venture partner is setting up an Indian joint venture, then one of the directors, minimum is just minimum limit is 1, needs to be a resident Indian, which means who's someone who has been here in India for 182 days and more. So this is a new requirement. Then you need just 4 board meetings in a year, 1 annual general meeting to be held. These are all minimum. AGM, of course, is only 1. And then, of course, whatever shareholder resolution you need to do, then you have to hold through the extraordinary general meeting. Thereafter, as and when any business is done, it requires certain kinds of compliances in terms of statutory filing of forms with the registrar of companies. That is from a corporate law perspective. Now, the company would have employees who would man the operations. So it will require certain registrations here with the employee state insurance department, then PF and EPF, and the local laws require registration with shops and commercial establishment, a certificate from there. And lastly, if the joint venture is regulated entity, for example, an NBFC, then it would also require, a Reserve Bank of India's license just because it chose to do a business which was regulated. So broadly, the compliances are there, but these are routine compliances for the JV partner. And of course, there will be operational and business compliances depending upon the business. But in my view, as I said earlier, LLPs also have almost similar requirements, although little less than a private limited company, in spite of the fact that private limited companies are a little more regulated than an LLP, but the form and its acceptance is widely accepted. And so the JV companies and JV partners do choose to take a private limited company as their preferred mode of entity to do the JV.
Perfect. So, just to add to this, I think this gives a very good overview of what really is required with respect to compliances. So if somebody wants to come into the country as a minority partner vis-a-vis a majority partner, how significantly different is the legal aspect? And eventually, as a minority partner, and I think we've all seen this in cases such as insurance and insurance agents in particular, wherein eventually FDI went up to 100%. But a lot of players continued to be majority partners, but they moved from a minority to majority JV partner in the country. So how different and how difficult it is when you're a minority versus a majority in the country?
So Prerna, this is a very good question. And in fact, most of our foreign clients and who are setting up joint venture, they also ask us that, how do we take this decision of being minority? Of course, commercial and business decisions being aside, but from a legal standpoint, they ask, how do we take this decision? So there are two aspects to it. One is the law, the legal part of it, and the other is contractual. Let's quickly talk about what is the legal aspect. See, from a legal standpoint, and the primary regulation and rule is the Companies Act. Until 10%, the Indian Companies Act actually does not give any real right, except, of course, you have the right to vote for your shares and get the dividends on the shares that you hold. But even for filing a case of operation and mismanagement, just giving you an example, or a class action suit, you need minimum 10%. So the legal rights trigger in law only at 10% from a Companies Act perspective. Then the next threshold is which is popularly known as 26%. Actually, it is 25% plus one share, because what that does to the JV partner who holds 25% plus one share, it can block the special resolutions by the majority partner. So that's the legal threshold, that with 25% plus one vote, you can block the special resolution. Then there are ordinary resolutions in company law, right? For example, even thing like payment of dividend is passed through an ordinary resolution. So ordinary resolutions can be passed with a 50% plus one share. So the JV partner who wants to get the control of the company in terms of passing all the ordinary resolution will choose to take 50% plus one share. And the last threshold is 76%, a majority partner, because with 76%, actually it is 75% plus one share, but popularly we say 76%. With 76%, virtually the majority partner controls the entire company, because the JV partner will be able to even block everything. Means nobody can stop, because with 76%, even special resolutions can be passed. There is no resolution in the company's law which requires unanimous shareholders vote. So the point that I'm trying to emphasize, Prerna, here is that the decision is dependent on what level you want to be, whether it is 10, which gives you a minority right, real legal minority right, 25% plus one share, 50% plus one share, or 75% plus one share. So that's the law. Contractually, the other bit is the joint venture agreement, which we write for the clients and for the JV partners. Contractually, you can get any right. For example, even with 8% shareholding, in the contract, you could write and get those rights which typically a 25% plus one shareholder would have. But it is not a legal right, but it's a contractual right which is agreed between the JV partners and enshrined in the company's articles of association, and it's binding on both of them and the company. So that's how it works. So then you asked me how easy or difficult it is to raise the investments. It's from a legal standpoint, it is not at all difficult. There are processes to increase the capital of the company, to preferential allotment or rights issue. So once the process of issuing further shares is followed, or sometimes the further shares are not issued, but the one JV partner transfers the shares to the other JV partner and increases the shareholding. So this is standard processes of issuance of shares or transfer of shares as is applicable, not very difficult. And legal regulations don't stop that. If you are within the sectoral cap, you are not breaching the sectoral cap in that sector, the government, the regulators are not very much concerned whether you are increasing the shareholding or not. So it's more driven by contract rather than law.
Great. Thank you so much, Lalit. This was absolutely helpful. Gaurav, I want to understand, we've got a good sense of taxation compliances, but you're looking at it on ground when you're going out and talking to a lot of SMEs and MNCs internationally to come and set up shop in India. What is the ground reality like? How often are these MNCs and SMEs looking to come to the country by way of a partnership, by way of a JV?
Right, Prerna. I think, again, it's a good point, because at the end of the day, when the rubber hits the road, you really get to know what the real numbers look like. I think it's pretty clear. India is an extremely attractive FDI destination. And it depends on various sectors, and more importantly, it depends on various types of industries that are looking to tap the consumer market that's available in India, right? Because at the end of the day, it's a function of who your customer is and what you're targeting and what you want to kind of cater to. So I guess from an overall perspective, it remains an extremely attractive market. There is no doubt about it at all. I haven't over the many years that I've been interacting with MNCs, I really haven't seen a conversation go by wherein if you're discussing international expansion, you won't look at India. It's extremely rare that any MNC who's looking at a large consumable market will not look at India with a great amount of depth. So I think out there is no disconnect in my mind or in the people's mind that who I speak with, that there is a significant amount of attraction to the country when it comes to setting up ventures. Now, obviously, a number of ventures come on their own, a number of ventures come through the joint venture route. And as also Lalit very clearly alluded to the fact around how these joint ventures are formed, there is always a concept of either a majority or a minority. In some cases, okay, as long as it's not regulatorily not allowed, i.e. sectors which are kind of opened up, in my experience, I have seen that a certain set of multinationals prefer to be a majority. And the only reason why they kind of look at preference to a majority is because at the end of the day, what they bring with them is a fairly large size global supply chain, which is attractive for the local joint venture partner also. Because at the end of the day, we all know that Indians and the Indian industry are extremely innovative in nature, are extremely engineering oriented in nature, are extremely scalable in nature from the kind of processes that they have set up for the domestic market. But what some of them lack, and what we've seen some of them can actually win, is the sheer scale of global supply chains. So some of these multinational companies not only bring some amount of technology that they have with them, but they also bring in a very strong inherent global supply chains which they come and share with the local joint venture partners. So depending again upon sectors, we've clearly seen the sense or the likelihood of wanting to have a little bit of a majority because of the various aspects that come around on a minority, as Lalit clearly pointed out. So in a nutshell, to answer your question, the reality is that it's extremely prevalent. The reality is that India is an extremely attractive market. The reality is that there are immense success stories of joint ventures in the country. And the reality also is that it's always a meeting of minds when you talk about the joint venture, because at the end of the day, the multinational player and the Indian promoter, the successful stories have always come from a fact as to how the ideologies are met. And at the outset itself, what has been the charter of the particular joint venture? So we'll talk more about it ahead in our conversation. But to round up, it's clearly a reality which has got enough legs on the ground, as we see.
Absolutely. Thank you so much for that. I think this is very, very helpful to understand, the perspective of what the foreign investors are and the ground reality of the positivity and the concerns that need to be kept in mind. We talk about concerns. I think globally, one aspect which is very important when somebody is coming in a joint venture is getting access to technology and R&D. Joint venture partnerships provide this technical know-how, technology, and there are, however, certain concerns of misuse or breach or even theft of the technical know-how. In fact, there are certain nations who are looking at their research in technology and protecting it in a very, very significant manner. So when foreign companies, Lalit, are looking to come in India and when they're looking to partner in India, how can they protect their IP?
Yes, this is also a very important and critical question, Prerna. See, as you said, joint ventures sometimes are entered to access the technology. So there are many generally in manufacturing and other sectors. So, and we have had successful joint ventures in India where, the foreign technology partner was giving the technology and the ventures were successful before they parted ways amicably. So for long years, I mean, one of the most important concerns for the JV partner would be, if that JV partner is the provider of the technology, is how to protect that, because everything will be known to the JV company and the other joint venture partners, and not only them, but their advisors and people who are actually running the operations. So it's a very important and a genuine concern. So how do we address that? See, first, contractually, first of all, the legal rights just don't pass away because the JV partner does not part with the technology or the technical know-how or license and other things. There are detailed agreements which are written whereby the technology or the technical know-how is licensed, and there are clear explanations, provisions which are given, for example, that it is not being given to the JV company exclusively, right? It should not be assignable. It cannot be assigned. It cannot be transferred. So there are so many restrictions where the agreements are written. Then, of course, the technology that you're talking about that would have been registered, or that would have been, if it's a patent or if it's any other technical know-how which is very unique, you have provisions under the IP laws and IP protection rights where you get the technology and get that particular thing patented and registered. Then third is, of course, the provisions relating to consequence and defaults. So for example, the defaults when misuse or theft or that all that you are saying. So there are both legal rights as well as contractual rights which are built in. The provisions that we write around confidentiality and the proprietary information that needs to be kept confidential, cannot be shared, all of that. And even people who are the JV companies or JV partners, employees, they will take control of that technology. So there are various ways to ensure, as far as law and as far as contracts are concerned, they are pretty standard as anywhere in the globe. And on this, even the Indian legal system, I would add here, views it very stringent as far as the user of the technology is concerned. What I'm trying to say is that even there are case laws, judicial precedents where the rights of the technology provider who owns the property and the IP is well protected, because the courts also give priority, because and to just grab or take, as you even use the word theft or they steal. Yeah, so there are instances, but of course in the process, when you learn what that JV partner's technology gives you, of course there will be some learning, to which what we do is we do write very stringent clauses in our agreement relating to even non-competes, which means that even if you know that technology, you would not be able to put that into operations and use, because you have a non-compete obligation not to do the same business otherwise than through the JV company. So there are checks and balances both in law and contracts, but yes, no denying the fact that the reality sometimes can be different. But even then, the way the agreements and law has been framed, I think it protects the provider of the technology or the owner of the technology.
Thank you. So we can suffice to say that we have a very strong judicial system which would protect any foreign investor who's looking to come in and partner in India with respect to their technologies and know-how.
Sure.
Perfect.
Yeah.
Thanks, Lalit. I think one more aspect that keeps coming in, and Gaurav, I request you to come in and talk a little about it, is the funding aspect. So, whenever somebody is coming to set up, coming into the country by way of a JV, they would, of course, infuse equity, but they are looking for financing options locally to raise debt. What are the various options that a JV can look at in the country? And, given the credit market in India and the stringent ECB guidelines for debt infusion from a parent country, how do JVs prepare themselves to be able to raise money and function in the country?
Right. Thanks, Brendan. I think when you look at, firstly, it's a company. Maybe the constitution of the company may be a joint venture based on shareholding. But at the end of the day, as bankers or as debt providers, we're dealing with a company. Now, I think clearly whether it's a 100% held entity or whether it's a joint venture, which is a majority or minority, the credit rating of that said company would obviously play a part in the various debt products that that company can raise onshore in India. So obviously a high rated or a high cash flow generating or a highly or a joint venture which has a very strong parentage attached to it has its level of access to the Indian credit market. But before we really dwell into that, let me just firstly retract on an important statement which talks about external commercial borrowing or ECBs. And let me be very clear that yes, the ECB was an extremely stringent form of financing, which has got materially liberalized over the years. So I think one of the things about the ECB, which is actually very important, and that's one of the things that I do quite relentlessly when I talk to multinationals overseas, around really educating the fact that the entire concept of the external commercial borrowing that the Reserve Bank of India has kind of liberalized has actually become a lot easier for multinationals to use as a form of financing, be it on a capital expenditure side or be it on a working capital side for their investments in India. So when you say investments, and if the investments happen to be in the form of a joint venture, really nothing changes from a ECB perspective. Because one of the things which is pretty clear to a large extent is that the interest rates prevailing in other parts of the world, i.e., specifically the United States or predominantly the Eurozone, are obviously a lot more benign to the interest rates that are still prevailing in India. That's just because of obviously the inflation numbers are different, the inflationary pressures of the geographies are different, and the benchmark at which you borrow in those geographies are different. So I guess from that perspective, it still makes a lot of sense for parents and multinationals who are investing into India to look at the external commercial borrowing route for their investment in a proper mixture between debt and equity. Because at the end of the day, the ECB does have the leverage ratios regulatory required as part of its as part of its requirement. But keeping that in mind and keeping the other aspects of taxation in mind, because and I know and I'm sure either Suraj would allude to that, is around the whole concept of thin capitalization, which is very much now I understand prevailing in India, and I know Suraj is the best to answer or touch upon that aspect. But keeping thin capitalization in or taking thin capitalization into account is also very important when you talk about the ECB structure. So I think, but after saying all this, what we have seen is that it's a good mix and match for a multinational to look at its equity and debt profile, keeping the external commercial borrowing route in mind. And we see that based on the type of the joint venture or based on the shareholding of the joint venture, we have seen a situation where MNCs will use their part of equity as an external commercial borrow, and the Indian partner will use his part of the equity as normal surpluses on in India. So given that, what kind of tends to happen then is that the capital base of the joint venture, which is equity and debt, becomes a very good mix of average weighted cost of finance, which obviously is much lower if you pump in a little bit more of the external commercial borrowing, only because of the rate of interest, which is a lot more benign. So one is the aspect of ECBs, which is still very much available to joint ventures. The other thing, obviously, is the various local financing tools that are available. And I think it's pretty clear that given the Reserve Bank of India's perspective on interest rates and the fact that how interest rates have come off in India over the last 12 to 18 months, India is in a place where interest rates have fallen to a remarkably low level. And based on the credit rating that the joint venture has, and I appreciate it because in a lot of our attendees' minds, there could be a question which says, okay, but this could be a startup. Okay, fine, this is a joint venture, but you know what? What if the joint venture really doesn't have any cash flows? Well, that's fine. I mean, when you look at when a banker looks at the whole debt profile, you look at what's the pedigree of the joint venture partners. What is the standing of the individual joint venture partners in their own credit market? And I guess when that comes together, and especially when you're dealing with an MNC that's known to a brand like HSBC, then it becomes a lot more easier for us to put a package in place to help this particular joint venture get off its feet in the local Indian market. So again, the entire product features, or rather the entire funding features that are available in the Indian market are very much available for a joint venture. It's really, there's no difference just because it's called a joint venture. But it is a function of the individual credit. And if it's not a cash generating business today in terms of cash flow generation, then it's a function of what's the pedigree of the parents. And more importantly, what is the implicit support that the parent is providing for this particular joint venture. So then you have structures such as corporate guarantees, structures such as personal guarantees that kind of come into play to help stitch up a good debt package. So Prerna, that's how it's kind of looked at across.
Perfect. Thank you. I think I totally agree with you. Whenever we are talking to foreign investors, the one thing that we tell all of them is that the minute there is no difference at all between a foreign company and an company or joint venture. So of course, everything that is available to a foreign company would be the same as an Indian company. So Suraj, can I request you to give your input, especially on the ECB aspects of what Gaurav just spoke about?
Sure. Thanks so much. So yeah, ECB is very much liberalized. I think it's sort of an open tap for manufacturing. Normal the ECB window and people, foreign investors, also always are keen to take money out. We have a window now which just requires a 1 year maturity, a minimum maturity, up to $50 million in manufacturing, including JV entities. Foreign money can come in and debt and can go. Otherwise, the normal period is 3 years. That's what the law is. And for working capital, etc., the JV partner overseas is also allowed to do a 5-year maturity program. So all that is allowed. Earlier, I think historically ECB was seen as only for capex financing, but that's today no longer the case in India. It can finance day-to-day operations, etc. From a tax perspective, two things become important. One is transfer pricing, because if it's coming, a JV shareholder essentially will be a related party from a taxation perspective. So while RBI or ECB norms cap the overall, cost of the ECB at a LIBOR plus 450 basis points, etc., we also need to sort of see benchmark it to what the corresponding cost for a similar credit rated profile borrower is, and do a little bit of compliance there. And second is the thin cap that Gaurav mentioned about. This applies to corporates who can raise ECBs, where the tax deduction of the interest today is limited to 30% of the EBITDA for a particular year. So it's not really stopping payment of that interest. It could still go through our exchange control. There's no restriction on repatriation of money from an interest standpoint or a banking standpoint. The only limitation is in the corporate tax computation. The interest deduction as an expenditure is capped at 30% of EBITDA. Essentially, and that also comes with a carry forward thing that you could carry forward any excess for the subsequent 7 years. So it does sort of have a fine balance. Sometimes if you want to, as per contract, commit money as debt, and even though you might get the tax benefit at in a deferred way rather than upfront. But yeah, not thin cap, as in it's not a prohibition to overly capitalize a company by way of debt. We have a normal 7:1 ratio, but that's again under FEMA, not in tax. So this is quite lucrative for JVs with foreign partners to bring that. Back to you.
Thank you, Suraj. That was most helpful. I think India as a country has seen a lot of successful joint ventures in the past. Of course, when we talk about Maruti Suzuki, it's a classic example. When we talk about successful partnerships in India, understanding the Indian market as we discussed earlier, how the perception and choices change is something that every foreign investor.
I think, Prerna, your voice is not clear. Please rejoin.
Hello, is it better now?
No, not better.
Okay, I will just put in a question for Gaurav and for Suraj to talk about learning from successful joint ventures, and I'll rejoin.
Sure. Thanks.
Thanks.
So yeah, we have a history of joint ventures. I mean, a lot of foreign companies, pre-independence, post-independence, as the economy kept moving up, joint ventures have always been the way of entering India. It is like getting married to someone, right? If you will look at it, it's like a business marriage of two people, having intent to do business together. And the learnings then for any marriage to be successful in joint ventures, also the most important thing is compatibility between the partners. That is extremely important. And this is not a very static. So while Lalit and Gaurav will stress us on that, yeah, you need agreements and all, but this is never intended to be static. It has to evolve as business changes, as circumstances changes, as economy changes. And the successful JVs are the ones which have evolved over a period of time. So while a JV agreement is fundamental and you need to spend time, get it right, not get very excited to do a JV before that architecture or foundation is laid out. But beyond that, you need to continuously evolve it. Few things that come to my mind just before you close a deal, is to get the right fitment of the partners. Culturally, it's important. It's also important to understand the Indian local partner. What are his aspirations on growth? What is the risk appetite? Depending on what business cycles the JV might go through. A lot of JV partners in India traditionally will be family-owned businesses, and today succession is also something that should be taken, into account on the current patriarch or leader of your local partner. What happens, if he's not around? Because traditionally, or most of the foreign investors are more institutionalized than, a large part of family businesses in India. So succession needs to be planned, factored, considered. And I heard Lalit mention clearly about the various thresholds and rights. I always think it's a degree of balance between how much you want to interfere and how much is your need for an oversight. I mean, it's always comforting to get to a 75+1 or a 76% because you think that uh, I can block anything that I don't like, but at the same time, it might just leave very little incentive or very little drive for your JV partner to contribute and to enjoy the economic rewards of that particular JV. So, few lawyers do, or your advisors, not just lawyers, get overboard when they try to cut a very fine deal. They say that we'll cut a deal which is in favor of a JV partner and sort of against the one, and where the JV partners start earning from each other rather than earning in the market. That is something that I would recommend clearly that you should avoid, and you should really looking at jointly developing something and earning from the market rather than making the JV as a profit center for one of the partners or trying to cut a very, very fine deal, which is a win-lose approach. It doesn't work that way. And my final point, I'll sort of love to hear Lalit and Gaurav on this, but the final thing that I've seen on successful JVs is the kind of autonomy that the management enjoys and, their own integration and loyalty. I mean, employees should also treat JV as a single unit and not have elegance or be more loyal to one of the parties, and if they along with that they have to be autonomy to operate, to take decisions, because if they're tied down through the consents or through the approvals and through every JV partners needing to have consensus, or if there is over domination by one of the partners, then the management will not be able to function. And that's where some of these JVs, no matter how good they were on paper or the Excel sheet, or how good the market opportunity is, it's just that the management team, which has to drive it at an operational level, the line managers, etc., they struggle to implement some of those JV decisions. But yeah, Gaurav, Lalit, if you would want to add to any of this, do pitch in.
Well, sure. I think, Suraj, I think extremely well encapsulated by you. There's no question about it. I think a couple of the points which I'll just maybe add on to what you just said is around the win-lose situation. And I think it's really important because the thinking of the joint venture partners, at least what I have seen in my experience, which has been successful, has been extremely aligned on what is it that we had set out to do. You know, whenever there is a significant diversification from core business, I guess that's where we've seen things really fall off between both the partners. The other important thing which we've seen in success is around already a buy-sale relationship being there between the two parties. So, one thing which has been very successful is where if there is an Indian exporter who has been consistently a large exporter to a large buyer overseas, and then the buyer really wants to look at an backward integration process, is where I've seen joint ventures get extremely successful because there's already been a very strong supply chain proposition built in between the two parties. So we've seen a number of these success stories which have always had some iota of a relationship in the past. And as you rightly put it, the ones which have succeeded going forward and which remain successful, especially between two families where succession is charted. There is just no doubt about that. We've also recently seen a lot of these examples wherein the heads of the businesses really agreed to something, but then over the years the generations followed and the succession has kind of fallen off interest in that particular business, and hence somebody ends up buying somebody or somebody ends up getting sold to somebody. So I think extremely important points, but it just boils down to the most important aspect of really charting out what is needed to be done at the outset. And that we have seen remains to a very successful ingredient in some of these joint ventures. And I really cannot over exaggerate the succession point, especially when you're dealing with family offices, family businesses, which is extremely important in the success of a joint venture. Lalit, anything you'd like to add to what we both just said?
Yeah, sure, Gaurav. Just taking the cue from your point, and then I'll come to a very good point which Suraj said. On this succession planning, let me tell you an experience. I think 3 years ago, we forced our client to write a JV agreement, which four friends had never written for 30 years. So they said, because our JV is running successfully, we don't need an agreement. So we said that you started something 30 years ago. Please think from this perspective that now you are passing the baton to the second generation. There would be chaos. I'm not saying there will be, there could be. So it took us at least 1 year of persuasion to at least guide them, tell them that be very careful, you don't have a JV agreement. So Gaurav, just to add what you said, actually 3 years ago, they wrote a formalized JV agreement saying that we were doing this for 30 years. And the sole reason they wrote was that we did not want any chaos and trouble to the next generation that they pass the baton to. So I completely agree with you that succession planning, and when the second generation comes, there could be difference of views and opinions. So things could fall out. And Suraj, the point that you mentioned, I also agree that sometimes legal documents do overdo the thing. So my perspective of, I have seen successful joint ventures. I've also seen joint ventures falling apart even within 3, 4, 5 years of entering. And trust me, while I'm not saying you don't need a legal document, you must need a very important, well-drafted and stitched legal agreements. But when it comes to a stage of dispute, you may write all these restrictions and transfer restrictions, non-compete, technology. But what boils down is, what do the parties want eventually? It boils down to the intent. It boils down whether they can carry the partnership or not. It's more to do with intention than what was written on piece of paper. So even if it is written, people will try to part ways and will see the loopholes in that legal document and try to wriggle out. So the failure, in my view, or success of a joint venture actually means, when two parties really want that to happen. I'll just share a little anecdote. Several years ago, we were setting up a joint venture for a foreign partner and Indian partner. In a large meeting room when we started by saying, giving a small piece of paper to two JV partners and said, just write 3 wish lists which you expect from your partner, and you don't see each other's chit paper. Trust me, and surprisingly, both sides had given 3 different objectives that didn't align. So as a starting point, we said, look, as JV partners, you don't seem to be even aligned when you are starting it. So that alignment bit is so critical. And of course, everything else, there is really no way. I mean, I'm a lawyer, I cannot avoid a pitfall. I might write the best agreement, but if it has to be successful, it will happen on its own. Of course, you have to take certain steps. But if it has to fail because of business and other reasons, or companies not doing well, and some force majeure has happened and business cannot continue well, people part ways. So that's my bit to it, Gaurav and Suraj. Over to you, Prerna.
Thank you so much. Apologies for the technical glitch. I hope it's better now. I would want to move on to a question which is a little more specific on manufacturing. So, Suraj, if I could get your views on specific restrictions that investors need to keep in mind for manufacturing sectors and other requirements in relation to pricing and valuations in particular in India.
All right. The good part is, we encourage FDI in manufacturing, so there are no restrictions. In fact, very recently, India has also permitted foreign investment in contract manufacturing. And this could be really big because manufacturing is high capex driven, whereas contract manufacturing is where you could outsource manufacturing to an existing person or an agency. It could be a P2P or a P2A outsourcing. So you could have JVs or even wholly owned subsidiaries in India doing manufacturing or doing contract manufacturing, no questions asked, automatic route FDI. And the benefit really is that what you manufacture or contract manufacture in India, you can sell in India across all formats. So you could do e-commerce, you could do retail. None of the, these sectors are otherwise restricted and controlled if you want to do multi-brand trading or e-commerce in India. But in relation to products that are made here, it is an open economy because we are encouraging foreign investments to come and have the Make in India initiative go forward. As far as pricing for investments is concerned, again, we just have a floor price where the money comes in, and there is a valuation required there. And currently, earlier we had a method restriction of only using a DCF. Currently, depending on the industry, depending on the sector, depending on the startup, any method that is relevant to that industry can be used to value that, and that valuation just becomes the floor price. The actual transaction can be at any level versus and at the time of exit, only if you're exiting to your local JV partner in India or to another resident in India, then again you have a cap on the valuation, which is again the fair value. But within the floor and the cap, essentially the parties are free to commercially negotiate, transact, and do business in. So there is flexibility. We also have instruments such as hybrids, which can convert into shares, etc. Which help to achieve commercial things around earnouts and milestones. You could have CCDs or CCPS, and for startups, something like convertible notes is there today, which is very similar to safe notes, what we see in Delaware or US companies. So all these things are very much codified part of law, very stable. So I think manufacturing is clearly very open and very, most foreign investors can come in and start that under the automatic route. There are no limitations also, if I may just add, we had a regime and some people still, relate to these old days where there were caps on the royalty or the technology fee, etc. All that is gone. There were caps on profit repatriation. All that is gone generally, whether to manufacturing or not. But today you could easily do all of that here without any limitation.
Perfect. Thank you so much. So anytime anybody is looking to invest in any country, be it India or outside, I think two aspects which are of course very important. One is profit generation. There has to be a viable business in that particular country. The second aspect which becomes really, really important is ease of exit. And if I can have Gaurav and Suraj talk a little bit about, so, Gaurav, let's start with a banking perspective. When a foreign partner is looking to repatriate money, of course it is revenue repatriation on a general basis, but at the time of exit, when there has to be a capital repatriation that happens, how easy is it? How complex can the process be in India, and how big a consideration is exit out of India and repatriation for investors who are looking to come in a JV in India?
No, absolutely, Prerna. I think it was always one of those areas which people always spoke a lot about in the international community, and there were phrases given to that as trapped cash, etc., etc. Whenever we looked at investing in India, specifically because of the tax regime or the tax rates. I think given that obviously the tax rates have kind of come off, at least from a liquidity repatriation perspective, that's something that's come off to a very large extent between the international community. Now, I guess once you are looking at an exit out of the country, there are very simple written rules about it, which the RBI prescribes in a format which is quite easy and accessible to kind of take a look at. And I guess from a banker's perspective, given that you are in line with the various FEMA laws which are there, which are again extremely elusive, to look at the whole repatriation purpose, and once you have a fair value, and more importantly, a kind of a clear regulatory perspective around what a legal connotation on it on fair value is, it's quite easy to look at the repatriation process. So I think today it's pretty clear, unless Suraj really wants to add in from his legal from his angle. But I haven't really come across too many issues where I've worked with firms such as Suraj's or Lalit's, wherein we've had a problem around a specific repatriation issue, as long as it is very much well within the laws of FEMA and the laws of fair valuation in terms of what the repatriation amount or what should be the sale amount, to be honest, to kind of get out of the country. I think one issue that kind of comes through, which is very, very important, and it's a very basic issue that I must touch on, is it's not that the process at the time of exit becomes an issue. The process gets complicated if at the time of entry, from a banking perspective, all the relevant documentation was not looked at. So for example, when you got in your equity at the beginning of formation, or when you got in your ECBs, or you've got in your remittances for equity or capital infusions during the course of the JV, if the documentation of that is not well recorded with the central bank of this country, which is RBI, and you want to look at a winding up or you want to look at a repatriation out, all those documents or all those proofs of ownership become a problem. And that's when you start getting into a slightly more enlarged representation or a conversation with the Central Bank of India to get the repatriation out of the country. So I think it all boils down to how it was set up, when it was set up, what was the documentation that was kind of recorded, and do we have the right recordings for that particular documentation to actually take the money out when we're trying to take it out. Suraj, would you agree? Would you like to add on that specifically?
I fully agree. I will just maybe add on to a tax and a regulatory point, and maybe on the regulatory one, I'll bring in Lalit as well. So currently, we have a very interesting. I think we, in the sort of urge to attract foreign investors, we actually have a tax rate which discriminates the residents actually. So our tax rate for foreign investors into India on long term is only 10% now. This rate has come down significantly, so it's become easy, and all the cash trap or the high tax on exit, all that is history. 10% again is a very competitive rate on capital gains, across most economies that are comparable to us. The second change also, which was allowed and which was a bone of contention, is to have a put option or a call option on your JV partner, both under corporate law and FEMA. So I'll maybe touch on the FEMA bit, and Lalit, you could contribute on the corporate law. But in FEMA now, RBI has specifically permitted, the JV partner to have a put or call on, let's say a put, right, a unilateral right to sell their shares to their Indian partner. And the only condition there is that you need to have a 1-year holding. And of course, no guaranteed exit. It will be done as per the floor and the cap, the valuations that we spoke about. But this is now very much enforceable, and there was a period of time where the Indian partners shied away from fulfilling this rights, even though the lawyers and the advisors put it in the agreement, saying that the laws didn't allow. So FEMA specifically today allows you to have this subject to pricing or fair valuation after 1 year, have a put call. And maybe Lalit, you can add on the corporate law change also, which has brought legitimacy to this.
Yeah, sure. Quickly on that point, Suraj, I think, yeah, so you're right that FEMA had little problem. That problem has been done away with the lock-in of 1 year and no assured return. Just to add here, there is and I will request all of you can also go through a very long and a very nice judgment in the Tata Docomo's case of Delhi High Court. An excellent judgment written, very long but very, very informative. There also, the Delhi High Court has held that Docomo, although both Tata and Docomo had agreed to pay the exit price, it was the Reserve Bank of India which intervened, and said that the price of the goods, price of the shares, beg your pardon, was not reflective of the price prevailing when the exit happened. So what the Delhi High Court said that what's being paid to Docomo was more as damages than as share consideration. It's a very interesting judgment, and I would request all of you to just at least go through this. So it's also added to the foreign investors' right to exit, although on ground sometimes this judgment is the only judgment, and bankers like Gaurav may say that okay, it's great, but every bank may have a different view. But there is legal precedent to it also, allowing the foreign investor to exit easily as per the contract. And of course, I agree with Gaurav. It's quite easy when you fill up the forms and take away the consideration. Of course, paperwork is there, but the banking transactions happens, in my experience, quite smoothly that way.
Thank you. I'm conscious of time, and I can see a lot of questions are coming in for the panel. So before I open it up, I have one last question. So, considering the fact that we are all bankers, CAs, and lawyers here, and we have recognized the ease that India has to provide, be it taxation, legal, the banking system, and we understand India is now open to a lot of investments. However, we are also conscious as a country of the fact that it's complex. Any foreign investor looking to come and invest in India would not know where to start with when they're looking for a partner. So as professionals, and if all three of you could give your view on how these professions can come into this picture and how can we help foreign investors find their right partner in India?
So if I may go first, I think
Please.
although Invest India was 2009, I think these professions were always driving the whole agenda of foreign investment banks in India, especially MNC banks, gave the comfort that, they are globally present as well as are there in India, as well as, the law firms and accounting advisory firms, chartered accountant, lawyers. So all of them have played an important role during this journey that, India is not as complex as perceived, and, it is sort of practical and easy to do business. We continue to do that, not just in terms of
Sorry, I think we may have
Yeah.
may have lost Suraj. Okay. No, I think Prerna, as Suraj was clearly saying it, I think everybody's playing a very large role about it, and Invest India is actually it's been really refreshing to see as to how you'll have been in the forefront for it. I think it's pretty clear. When I do a lot of roadshows, I do a lot of travel across where, as Suraj was rightly saying, it is sometimes become a theoretical conversation that it's very difficult to do work in India. No, I think it's a question of educating. And I've seen that very, very well. That as and when you have constituents that educate, what is it that works in India? I think it's very simple. That the thing is, you need to understand it's a regulated country. It depends on which part of investors are you looking at. If you're looking at investors coming in from Europe specifically, it's slightly difficult because the regulations are very different there, or are a lot more lucid there from an overall perspective. So I guess once you educate them, this is how things work, and this is what you need to do, A, B, C, D, then life gets a lot more easier for people to kind of understand that. So I think in a very simple language to help to make people understand as to what are we doing to promote conversations, it's a lot about really having one-to-one or multiple conversations with our existing companies, really mapping out ecosystems. I mean, I have seen a significant amount of success when you are looking at mapping out ecosystems and then reaching out to the constituents of those ecosystems to really come and set shop or look at the opportunity that the country has to offer. And one of the things that HSBC has been absolutely in the forefront for the last many years is to pick the sectors wherein there's a lot of conversation, where there's a lot of FDI push, where there's a lot of specific deregulation of the FDI policy, and really map out the ecosystem of those manufacturers and invite them through the anchor, through the manufacturer, to really come and take a look as to what's the opportunity to set shop in India. So I guess it's a combination of a lot of these efforts. Yeah.
Thank you. Lalit, can we request you to give in your inputs? And I think Suraj is back on.
Sure, Prerna. I think as lawyers, we have a little limited role in scouting for JV partners. I think that's done most by financial services firms, chartered accountants and bankers like Gaurav. I think the only way we can connect, it's mostly when we interact with a lot of major foreign law firms. In turn, they have their clients, we have clients here. Sometimes they might ask that, we are looking for an exit or a JV partner or a good JV company. And of course, we have some Indian clients who had placed similar requests with us. We can help each other meet, I think. And of course, we go out and also showcase something like what Invest India does, but we do it in our own capacity to showcase in our brochures and in our investments in India, ease of investments in India. There are ways to let foreign investors know. But when it comes to getting a JV partner in India, I think I must confess and be candid that lawyers would have a little limited role than bankers.
Point completely taken, Lalit. Thank you so much. Suraj, over to you.
No, thanks. And sorry, I just had a blackout situation. But what I heard, Lalit, and I think lawyers are, the pundit to ensure that the marriage happens. And bankers and others, we will be the guys who will continue the matchmaking and getting people to transact. So yeah, as a common ecosystem and, under the aegis of ICAI, everyone, I mean, all of us owe to contribute to developing and, further deepening this whole way where foreign investors come here, do business here, and are comfortable with the outcome.
Thank you. And as Invest India, I'd like to input this as well. Invest India has been focused on getting more and more partnerships. We do focus on letting in foreign investors know the benefits of coming in a partnership. And to be able to do that, considering we're a government organization and we can't do one-to-one matching, we've come up with something called the India Investment Grid, wherein any local player who's looking for a partner can actually come in and showcase their interest if they're looking for technology or funding or a strategic investor partnership from outside. And any foreign investor who's looking at India, we do ask them to go and take a look and basis their interest of sector, geography, market cap, sizing, they can actually identify local partners. We have all embassies and all of us continue to pitch it, and we do let people know the benefit of JVs and how it is that forums like this and institutes like ICAI and bankers and chartered accountants can actually help them in finding the right kind of partner. Thank you so much. I have a set of questions that have come up. We'll try and cover as much as we can in the limited time that we now have. And I'd request all panelists to actually step in and jump in and answer as many questions that you would have, that you can. The first question that came in is how should joint venture partners manage differences? Historically, we have seen that most of JVs are not successful, or there are challenges in managing the softer aspects of ideologies in JVs. So, Lalit, would you want to give some views on the legal aspect of how to take care of this?
So Prerna, I think in my view, as we earlier also mentioned, it's more to do with intentions, alignment, and how much do they expect from the JV and how do they want to govern it and manage their relationship. Of course, when acquisitions happen or JVs have been set up post inorganic growth, of course, there are differences of culture and HR issues and all of those. So of course, there are softer landing if it is not a greenfield JV, if it is through inorganic acquisition. So there are ways to ensure there's softer landing, and people tend to get culturally and commercially and even from a perspective of human resources, all of these, they align. But as far as my role is concerned, I have a job to write a document which actually puts both the parties' rights, obligations in place, foresees situations what could arise, provide for them, so that just because of legal documentation and compliances, the JV does not fall apart. Rest, I think maybe I would only add this, that really beyond that, from a legal perspective, one cannot do things. But yes, relationship, as in any interaction, relationship, how they are managed, it will not be any different really in the JV company.
Thank you. The next question is on the fact that how are Indian companies open to JVs? How does one find a foreign company for a partnership, and is there a special platform? I think I did answer a bit of that by the platform that Invest India has. Please do take a look at our website, and you'll be able to access it. The next one, Suraj, is for you. Are there any withholding taxes?
Quite a generic question, but
Yes.
if it is in the context of dividend from a company now, because the DDT has gone, maybe that is where I mentioned withholding tax. So yeah, there are withholding tax on dividends now, and that rate will now depend on the specific country and tax treaty where the investor is coming from. There are also withholding tax on interest payments on ECBs. Again, the rate, there is a domestic rate, but normally most countries with which whom we have tax treaties have favorable rates.
Thank you. The next one is how can free trade deals with India change the scenario of foreign JVs in India? Or what are the barriers in creating a JV that any free trade deal can uproot? Suraj, would you want to take this one? Or maybe Gaurav?
Yeah, this is not my zone. So if Gaurav or Lalit I would speculate on this.
Yeah, I think Prerna, I'd be happy to answer it if we take the question down and maybe give an answer later, because it's not very specific, to be honest.
Sure. So I think the one thing that I can probably add here is whenever there is a free trade agreement with a particular country, for example, India has FTAs with Southeast Asian countries like Vietnam. The aspect that can help us here is the fact that we can start looking at these markets from a perspective of selling there. Of course, it is cheaper with the FTA, and I think that is where partnerships can be made internationally with all other countries with the focus of targeting these markets. In addition, if there is anything particular, so I think the one constraint that we've seen with FTAs is, for example, the fact that India does not have FTAs right now with Europe and US in a lot of sectors, because of which we've seen some flow of money moving to Southeast Asian countries, but in particular for JVs, it does not matter whether you have an FTA or not. It's more so about attracting investments in a particular sector. There are quite a few questions on ECB for LLPs. So a lot of people would want to confirm, can an LLP get ECBs or not?
I think the position is fairly clear now. RBI has clarified that ECBs are not permitted to LLPs. That is the law the way it stands today. There is no way, if your plan is to get ECBs, then a corporate structure is the only way to get them.
Thank you. The next one is any restrictions on FDI for small scale industries, that if any item which is to be manufactured by a small scale industry, would there be FDI restrictions? I think I can answer that by saying there are no restrictions on FDI. However, the one aspect that is coming in now is that if there are tenders below 200 crores, they would mandatorily need to be procured from an Indian entity. Having said that, if a foreign investor comes in and sets up a manufacturing unit in India, then we can procure from them as well. The only restriction is now that there would not be any import of products when a tender is below 200 crores, as long as it is available in the country. If any panelists would want to add to that before I move on.
I think Prerna, you're right. But the also thing is, if I'm not mistaken, the government has been quite keen on promoting FDI into the sectors such as footwear, furniture, and I clearly understand food processing is also a very important sector where the FDI promotion has been quite vocal as per my understanding. Please correct me, Prerna. But I think these are clearly sectors which are very close to the SME's heart, and this is clearly something where you can see a lot more of FDI that some of the large brands would be really interested in. So I think that's I was quite happy to see footwear and furniture in the revised list, which kindly alludes to the fact that they are promoting some amount of FDI in these sectors.
Totally agree with you. Moving on, what will be the likely liabilities of a joint venture, and can these be mitigated by a limited liability? How can indemnities and insurance further manage the risk profile?
I can take that, Prerna. I think the reason of setting up a company is, and company, as everyone would know, is limited liability. So is LLP now, unlike a traditional partnership. So these, both LLP and company form of organization, actually limit the liability as far as the shareholders are concerned. And the law is that the JV partner in this case, as a shareholder, will not be required to contribute anything more than the unpaid share capital towards the company. So to that extent, the liability of the joint venture partner is limited. For example, in a failed joint venture, and the company needs to be wound up, and the proceeds will be distributed to creditors and eventually to the shareholders. Now, if the proceeds fall short, the joint venture partners will not be asked to fill in the gap or fill in that hole, because the liability of that JV partner, because of the entity it has invested in, is limited. As far as the indemnity and other things are concerned, they are contractual. So if someone has written in a contract that if in the event a certain thing goes wrong, or a certain representation and warranty go wrong, or a provision of the agreement goes wrong, and I would indemnify you. So that is contractually driven. Even in contractual provisions, we do add limitation of liability clauses, both in terms of the time up to which the liability will last and threshold cap on the amount. And there is also Limitation Act and Limitation Law in India, which also legally fixes the liability, sometimes to 3 years, depending upon the claim, sometimes to 12 years. And there are different limitation period given in law. So to answer this question, yes, liabilities can be limited by setting up that company in that form and contractually with respect to indemnities.
Thank you so much. The next one is also for you, Lalit. To what extent are contractual terms enforceable compared to legal rights given the judiciary system in India?
Yeah, it's a very good and a very interesting question for a lawyer always, because when we write contracts, so legal rights are the best right. I mean, whether you write or even give up, so much so that even if you give up your legal rights, for example, that I will not dispute against you, that is not even enforceable in law. So legal rights are the supreme. There is no denying this fact. But when it comes to contractual right, all contractual rights are enforceable as long as the terms are within the purview or within the provisions of law. For example, Suraj made a point that in a put option, you cannot, after putting the shares after 1 year, take the shares at that fair market value at that point in time, not assured return. If you provide in your contract that I will get an assured return, this goes contrary to law, of course this will not be enforceable. So contractual rights which do not impede or which do not come in conflict with law, they will be enforceable. And in a JV agreement, most of the rights and most of the agreements are written keeping that in mind. And wherever there is doubt, whenever there is a problem, there are ways and mechanisms to overcome that so that the agreement does not play foul of the law, because otherwise it will become unenforceable.
Thank you. The next question is on tangible progress which has been made towards streamlining regulations and process of the chemicals industry. I'm sorry, I don't think we have chemicals experts here, but what I can do is I can put you in touch with the chemicals team at Invest India, and we can probably help you in answer this question. So I would put in my email address in the chat later, and you can send across your specific query to me. Moving on, there is a question on Press Note 3, which of course has been something in talks for a while now. The intention of the Press Note is, of course, to attract foreign investors, but after Press Note 3, the concept of beneficial owner has been brought back in. How is this going to affect the Indian market? Gentlemen, anybody would want to take that?
Yeah, I would take that.
I think we're losing Suraj again.
Can you hear me? Can you hear me well? Hello? Can you hear me?
Yes, can.
All right. So Press Note 3 essentially was a slightly knee-jerk reaction in April, in response to what most economies had, done to sort of protect, assets getting sold cheaply. And, there was one economy which was coming out faster out of this crisis. So the law came in, I would say, more knee-jerk. Imagine even bureaucracy not functioning in middle of April, in the middle of lockdown, for them to come up with a law. And we should just take it at that, right? That it was a response to a stimulant. And as things sort of evolve, either it will get clarified, diluted, or simplified so that the normal functioning of the sectors which are not of national importance. I suspect that we will expect far more clarifications on how that Press Note 3 or what is it intending to protect, rather than function like a blanket. It's still not a restriction, it's only a screening process. So money is still coming in, and there is a process through which it needs to go through. So I would say it just has a little bit of a intangible impact, but things are still progressing. The business is still happening.
Absolutely. I think considering the fact that we work very, very closely and we are a body of DPIIT, Ministry of Commerce, who came out with the Press Note, I can tell you the idea is, and we don't shy away from saying that national interest over anything else, and this was done in national interest. However, there are no restrictions. The process of approval of investments coming in through a certain set of countries is already in place, as Suraj was mentioning. It's an online process, and it's been expedited to make sure that there are no concerns that any investors face. However, considering national investment interest, they would first be streamlined and screened. Thank you for that, Suraj. Lalit, the next question is maybe for you, which is how does profit allocation work in JV with the main partner?
So Prerna, it's nothing unusual here. See, they are shareholders. So if it is LLP, then they will be capital contribution. And if it is a company, then they will be holding shares. So the simple general rule is that in the proportion that they hold their capital contribution or shares respectively, the profits are divided on the basis of that. Of course, there are some legal issues there. For dividend, for example, under the Companies Act, dividend can only be paid when there is profit in the company. Otherwise, it's not possible. So the allocation of profit is mostly on the basis of the capital contribution. However, in the joint venture agreement, we do have a clause which says dividend policy, which means that the JV partners decide that even if there is a profit of say 100, they want to use that in future purposes and business and keep it as reserve. So they will decide to distribute in say year 1 or year 2 much less than the entire amount. All that is contractually written. But basically, the division is just as per their, unless otherwise agreed. If it is otherwise agreed, then one JV partner will have to pass on the profits after taking it from the company to the other JV partner. But that's not usual, which is why people split their shareholding rights in a manner that both voting rights as well as economic rights through dividend can be shared in that proportion.
Thank you so much. One more for you. Is it required for a foreign partner to be in India to promote a company? Or in cases if such foreign partners can actually be a promoter without his presence in India? And then what are the hindrances he will need to face?
There's no legal requirement. I mean, you can have a foreign partner who can be the promoter of the Indian company in joint venture with Indian partner. So the Indian partner will be the non-lead JV partner. So there is, first of all, there is no restriction, there is no problem. And the presence in India will also not be required, except of course, as I said earlier, that if the partner wants that I should be a director, I should personally be a director, and there is a requirement of one Indian director, but that necessarily is not of the foreign promoter. The Indian law requires just one Indian resident director that can be an Indian as well as foreign. So in short, there is no restriction. But how to overcome hindrance if you are not present in India? I think, yeah, of course, if the operations are happening in India, either you have a trusted team which is sent from abroad, or you have a trusted team in India who's undertaking operations. You come here, visit. All are ways to do it. But these are general hindrances, but there's no legal hindrance that you will face if you are not in India. That doesn't happen.
Yeah, but maybe if I could just come in from a banking perspective, I think it's important, given the know your customer guidelines and the beneficial ownership and the connected parties that could be there in terms of the authorized signatories, if at all. I think with these kind of aspects, it could come into some sort of hindrance from a banking law perspective, because you require the relevant KYC, require the relevant documentation, the entire identification, verification, etc. So there are some nuances around it, okay, which could become a little bit more troublesome for the particular investor, especially if the investor wants control. Or as lightly put it, especially if the investor wants to be operationally active. But even if they're not operationally active, from a KYC standpoint, all the relevant beneficial owner details will always be.
Thank you so much, Gaurav. Sorry, I interrupted. Lalit, there's another one coming in for you. So you mentioned about RBI approval, which is needed for unincorporated JVs. One of our audience members wants to know if this requirement is under FEMA, because as their understanding is that FEMA does not talk about unincorporated JVs. So what is the law that would guide this?
So the person who's posed the question is absolutely right. There is nothing written specifically in FEMA guidelines where it says unincorporated ventures require uh, RBI approval. So how it works is that if you read the NDI rules, the rules which govern foreign investments, they only talk about LLPs and company, right? They also don't talk about things like, say, society, trust, but in any case, that's not even where FDI comes, because just from a legal standpoint, I'm explaining. So it only talks about company and LLP. So this is the regulation which governs foreign investment. So it's silent about an entity which is neither a company nor an LLP. There is another regulation where it says setting up of offices in India, project office, liaison office, and any other place of business. An unincorporated joint venture is generally, if it does not fall as a, say, if the unincorporated joint venture has been set up as a project office, right? So then it will be construed as a project office to undertake a project. Then in that case, according to the other regulations, if you fulfill the conditions of being the project office, then it will not require approval. Or there are branch offices. If you set up the JV in as a branch to do some business, then also you would not require. But if all these things are not met as a branch office or a project office, and you just want to set up a full-fledged joint venture, which is not project or branch office, then it falls in the residual category of that regulation, and where it says if you do any other business by any other means in India, it requires RBI approval. So it's coming in directly from there.
Thank you so much. Uh, Also, can you throw a little bit of a light on obligations and liabilities of a JV partner of a foreign investor under various thresholds of 10, 26, 49, and 74%?
See, under Indian law, Prerna, there is really no obligation of a shareholder. If obligations are there, they will be of directors. And directors' obligations are fiduciary duties, and that is irrespective of percentages. So if you are a director of an Indian JV company, the liabilities will be there, and rights will also be there, both. But when it comes to JV partner in the capacity of a shareholder, there are really no obligations on a shareholder. What the law gives is only right. So when I was mentioning about 10%, 25% plus one share, 50% plus one share, and then 75% plus one share, I was talking about the right which one gets in the company or even in the LLP through the legal statutes, legal provisions. So truly there is no obligation, so to say. However, having said that, there are obligations of promoters, far and fetched as far as unlisted companies are concerned. So if the JV partner is a promoter, yes, there is some provisions in the Companies Act where the expectation from promoters is a little higher than other shareholders. And for listed companies, of course, when the JV partner is in a listed company, then there'll be a plethora of obligations, not from the capacity of shareholder, but from the capacity of being a promoter.
Absolutely, totally agree. Gaurav, this one's for you. So you had mentioned about how issues preliminary in a partnership in the ownership document at the equity injection time could have certain impact on the repatriation. Our audience wants to know a little more, and if you could give some examples on the kind of issues that could arise if the documentation has not been done
No,
correctly.
sure. Absolutely. I think when it comes to the, say, for example, when you bring in equity into the country, you need to have the various FCTRS, FCGPA filings that you need to file with the regulator, which basically shows the ownership or shows as to who is the shareholder and where does the equity come from. I've had number of instances, and this is a follow-on thing, right? Because what you sometimes within joint ventures, you'll have an equity that comes at once, and then you'll have some follow-on equities that come in based on growth, or you'll have an external commercial borrowing that may have been taken where they have the ECB filings, which need to be done on a regular basis. So specifically in either a stake sale situation or a stake enhancement situation, or in the worst case scenario of a winding up of a particular joint venture when we're trying to repatriate, we've noticed that sometimes the joint venture partners have not worked with an authorized dealer in a manner where the authorized dealer has gone and made these submissions and these recordings with the RBI. And when these documents don't get done in that manner, that's when the problem starts. So we at HSBC take this very seriously, because when we are an authorized dealer for a particular company or for a set of investors or for our customer over here. It is something that we follow on with both the joint venture, which is the legal entity over here, and the recorder, which is the Reserve Bank of India, on making sure that this paperwork is done in a manner which is needed by law. And one of the things that I always opine when I'm early, obviously, my friends Lalit and Suraj will always get in this particular conversation a lot earlier, given their respective roles. But as a banker, when you kind of come in and if you're working with a lawyer or a chartered accountant who's advising the company on either a stake enhancement or a stake dilution, the first thing that I always say as a banker is, please give me a record of your earlier conversations or a record of your earlier documents. Because I've always seen that at the 11th hour, if that was not done properly, we get into conversations with RBI such as compounding or representation, which talks about taking care of the previous filing document. So that's it's a very, very basic, but an extremely important point when it comes to these three kind of situations.
Thank you. The next one is, what is the possibility of any fiscal stability when an outside company enters into India in any sector? Suraj, would you want to take that one?
A fairly open-ended question, but let me maybe address it from a tax standpoint. And we had a reputation of making, let's say, retrospective changes to laws, etc. I think the government is now committed, and we've seen that for at least last 6 or 7 budgets, that there will be no changes or that would be retrospective. So everything that got done recently, whether changing the treaties, laws, etc., is all being done prospectively, or all being done with grandfathering, like even when we bought capital gains tax on listed shares. So stability in that extent today as a stated policy for tax is clearly enshrined, and it was sort of even part of the speech of one of our earlier finance ministers, that the government will refrain from doing that because that sends out a wrong message. On the other policy side, on fiscal side, I mean, these are interesting times. The government will always want to provide that stability because even the domestic folks need it. But there will be those situations where you might have to take decisions which will impact everyone, not just JVs in particular. But tax and SEMA will, I think that's where it impacts most. We've not seen anything that gone back in circles or taken something 10 years behind from where we were. It's just getting simpler and stable and easier. I mean, it's throwing professionals out of jobs if someone wants to get an idea.
Thank you so much for that. So there are quite a few questions, in fact, on the tax aspects of repatriation to foreign investors. They want to understand the taxations on both the profits and at the time of exit.
Again, slightly detailed oriented, I can send a note which you could send to the concerned participants. But essentially, for a company, once you pay a tax at a corporate tax, what we call an income tax, that is a tax on the company on the profit it earns. Distribution of that to the shareholders today is taxable in the hands of the shareholders, and all the company needs to do is a withholding on that distribution, whether it's to a resident shareholder or a foreign shareholder. And each shareholder then will pay tax according to their jurisdiction and status. On exit, for non-residents, as I mentioned, we have a 10% tax rate for long-term capital gains, which for unlisted companies is a holding period of 24 months. Once you've held shares of a company for more than 24 months, as a non-resident, you will pay only 10% tax. And if it's a listed firm, that holding period comes down to 12 months. So this is essentially the broad framework, and there are some nuanced rules. I'll note which Prerna, you can share.
Certainly, that would be helpful. Thank you so much. There's a specific question which has come on R&D, but instead of going into the question, I'd like to understand how do startups look at it? So if a startup wants to come in with a partnership, and in this particular case with a research group, is JV an option for them? How is it that they should try and approach partnerships in India?
I can take that up, Prerna. I think for startups also, See, JVs anyone can do, but for me, my experience has been for startups, it's more to get a capital, which is a financial investment. That's my experience. There is no hindrance in law to set up a joint venture, even by a startup. But primarily, they access PE funds and financial investments and seed funding or VC stage, and that's how they get their capital, not truly from as a joint venture. Joint venture is a little more strategic. There is a long-term partnership. That's what it means. So having said that, but if a startup also wants to set up, I think the rules and regulations will be the same. Whatever provisions will apply to a normal full-blown and fully capitalized company, a large company, I don't think so. It will be any different for a startup.
Prerna has lost the connection.
Sorry, I think there was an issue, but I'm back on without the video. In interest of time, should I go on with questions, or should we collate answers and have them sent across later?
I think, Prerna, if you're okay with that, let's collate some answers if at all. I apologize. I had a commitment at 4 and hence I'll have to leave with your permission.
Certainly. So I think we can conclude. Apologies, we couldn't take all questions. I know we have questions coming in on YouTube as well, but we'll collate all of them and send across answers. Over to Mr. Dheeraj Khandelwal to summarize and give his vote of thanks.
Yeah, thank you, Prerna. I think it's one of the wonderful interactive session on the ease of doing business in India. And Suraj, Gaurav, and Dalit has both, all three has spoke well on the starting from the incorporation of the company, the taxation part of it, legal angles, and JV partnership and investment, whether it's a stake in 75% or 51% or 26%, importance on this aspect, which is very important. People hardly aware of that. What is the importance of having a 25% or 25 plus 1% or 1 shares, or 50% and plus 1%. It's an amazing interactive session. I'm hearing the number of questions. I'm seeing that a lot of questions are coming on each and every aspects, and the well answered by the Gaurav also on the banking side, and the how the KYC's norms are there. So amazing session. I believe that such kind of session has to be much more in on frequent basis in across the different countries. We should have a kind of a demo or such kind of meetings there in the different countries. Definitely people are from India also benefited in such a conference. I really thankful to the Invest India on behalf of the ICA, and I'll thank to the Lalit, Suraj, and Vinod for excellent coverage, excellent thought process being covered entirely with very lucid manner, very simplicity manner, and explained in each and every aspect. So I really thankful on behalf of ICI and the chairman as well as and everyone, and Prerna, very well done, very well conducted, and I hope that most of the queries have been answered, but there are a lot of concurrent queries are there on the different personalized queries. Definitely well said by the Prerna. You will collate them and answer them in differently. So it's going to be lovely. So thank you for all for having wonderful session. Thank you very much.
Thank you so much, sir. With that, we would conclude this session. Hopefully, in these 2 hours, we would have been able to answer a lot of questions that everybody had.
Thank you. Thank you.
Thank you,
you,
everyone.
Mr.
Thank you very much. Thank you.
Thank you, everyone.
Thank you, Suraj ji. Thank you, Lalit ji. Thank you, Gaurav ji, and co-chairman Dheeraj ji also. Thank you, Prerna, to you also. Thank you very much.
Thank you.